Hello everyone, I am Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School, and I'd like to provide a little bit of information that we would be covering in Class 3 for sales. Recall that we are still dealing with Article 3 of the Uniform Commercial Code, and of course in a particular state, that state's adoption of Article 3. Last time we talked about the shelter rule. Very simple idea. If there are two parties to a contract and one makes a note or a draft, the other party receives that note or draft, he or she may want to be paid now and not hold that cash or that note or that draft. And so he or she turns it over to somebody else for cash. That person who buys it for cash often is completely unaware of the underlying contract, of the underlying dynamics, of warranties of merchantability, or any other problem that the two original parties may have been aware of. This third party buys innocently, and we need to protect that third party. And that is the primary information or issue that we deal with a little bit later today. Okay, assuming though that this third party who buys a negotiable instrument is completely innocent and deserves holder in due course status to be defined later today, what if that person trades it to someone else, fourth party? And let's say it's not for value. If it's not for value, that fourth party is not a holder in due course. And yet that fourth party did nothing wrong, did not know anything about the underlying problems, if there were any. Okay? And finally, that fourth party, if he or she's not paid out, can simply give the note back to the prior holder in due course. That prior holder in due course can then assert the right to payment, and so the person who made the note or wrote the draft is going to have to pay it anyway. And so it does not make sense. You might not be able to call somebody a holder in due course as a fourth or fifth or sixth party, but they might still be holders entitled to exercise the rights of that prior holder in due course. Of course, if this fourth or fifth or sixth party that takes on a negotiable instrument actually helped to create a bad instrument or was otherwise party to some fraud or some shenanigans, and he or she knew it, then the ability as a holder to benefit from holder in due course status should probably be taken away, okay? Because there'd be a guilty knowledge. Keep in mind, though, you've got holders in due course, and you have other parties who don't qualify as holders in due course, but yet they still deserve the same protections, and so we use the shelter rule to blanket them with the same protections that a prior holder in due course had transferred, has assigned to them. Okay? A debt collection company that buys bad debt. How can it get away with that? It knows that something's been dishonored and not paid. It's aware of a problem. It's the shelter rule. So if somebody innocently buys a note or buys a draft, not knowing of any underlying shenanigans, not seeing on the face any problems. It looks good and the person buys it in good faith, for value, very honestly, etc., etc. Then he or she deserves to be paid. And when he or she's not paid, there's a problem, and it's a point where people become aware that there is a problem on payment. But that holder in due course still deserves payment even if it can't be made right away. Why not let him or her transfer it to another party who had nothing to do with anything bad in the past, nothing to do with the bad parts, at a discount, at a serious discount. And so these collection companies can find bad debt, pay 10 cents on the dollar, and pray to collect 15 or 20%, and it's a good deal. You've got a holder in due course who wants to get rid of it and agrees to get rid of it at a low price. You've got an innocent fourth party who wants to take this bad debt and collect it, and the only way to do that is to be able to borrow holder in due course status. They are not holders in due course. They know there is a problem, but they are protected by the shelter rule, and so they can borrow their transferor's holder in due course status. Make sure when you deal with a situation like that, however, you don't call them holders in due course. You may have a holder in due course, another one buys it, holder in due course, another one buys it, he or she's the third holder in due course, that third one gives away the note as a gift. That fourth party is not a holder in due course. There's no value. And so that party would be a party via the shelter rule entitled to assert the holder in due course status that he or she got from her transferor, who has the right to assert what he or she got as a holder in due course taken from the prior holder in due course, etc., etc. Okay? There are a few things today I may talk about later, but let's talk about the most important thing today. When you are a holder in due course, when you buy a note as a third party from two other parties who probably had a contractual relationship and created some debt obligation, a negotiable instrument, you buy that note without knowing about the underlying deal, without having created the note or done anything bad in the past. You come in simply as an investor without knowledge of anything bad. You should be protected. We say that holders in due course are super plaintiffs. And the reason why is there are certain defenses that the maker of a note or the drawer of a draft can use against the first party, the payee. If I buy goods from you and I write a check, I'm the drawer, you're the payee. You breach the contract by sending me inferior goods. I could call to stop payment on that check. You can sue me to try and make me pay, but I can defend by saying you breached. You see why I didn't have to pay? Right? I can use the contractual defense of your breach to stop paying. Where the instrument has gone to an innocent third party, you can't use those defenses. So those innocent third parties deserve extra protections. And that, in fact, is what induces these parties to buy these notes. We like the idea of negotiable instruments. We have to give parties who take them in good faith a certain amount of protections. And so for certain defenses, we call the personal defenses, holders in due course don't have to worry about those. Prior parties cannot assert those personal defenses against holders in due course, and even holders who are able to borrow or share in the benefits of a prior holder in due course. There are several defenses, however, that we call the real defenses, that are assertable anytime, anywhere, even against holders in due course. In effect, it's a public policy which runs in the nature of being so important that we need to use it as a proper defense forever and for everybody. No amount of innocence will wash this clean. We're sorry about that, but public policy in this case takes precedence. An example is infancy. And there's another example, fraud in fact. If you sell me something by fraud, if you try to sue me on my promise to pay you, I can defend by asserting fraud. Well, that fraud problem will actually go along with the note. It's one of these real defenses that lasts forever. And so if a holder in due course grabs the note and tries to collect, the party can assert one of these real defenses, like, well, there was a fraud in fact, so the note is not supported by any current intent. Infancy. The person who wrote the note is a 5-year-old. I buy a note and Ed Smith looks good to me, but he's only 5. So whereas I can't see anything wrong, I'm not going to knock on the door of Ed Smith and ask how old he is. I just buy it. Okay? But if he's 5 years old, public policy does not want to make that person contractually responsible for that debt. And so to some degree, I buy as a holder in due course or as an attempted holder in due course with a certain amount of risk. So to some degree, I have to be careful, or I have to take this win some, lose some approach, because that could happen. But the personal defenses, like I'm not paying you, the car you sold me was bad, holders in due course are free from those personal defenses, and that makes them much more valuable, makes them much more transferable. If on these notes, if these negotiable instruments, notes or drafts, were too hard to enforce, no one would buy them. And if no one would buy them, we wouldn't have commercial paper as an industry. We like it. And so keep in mind, we very often try to protect holders in due course to maintain the market for negotiable instruments. There is a point, however, where something is so serious, something is so wrong, that we don't give protections to holders in due course. And then holders in due course should simply be a little bit more careful when they take these notes. Okay, so remember, the real defenses such as infancy, certain kinds of fraud, significant legal invalidity void as a matter of public policy based on a law, that too is the kind of real defense, if it's the right kind of underlying crime, that will remove holder in due course status. It is assertable against a holder in due course, as well as it's assertable against the person who actually made the note or who made the draft. Okay? So keep in mind, holders in due course are protected from the personal defenses. Holders in due course are not free from the assertion of real defenses. If someone is an assignee of a contract, right, I buy your car. I sign a note to pay you. If there's something wrong with the car and you try to sue to collect on the note, I can defend and say you breached. You are still holding the note. You are a holder of the note. But I have the right to assert personal defenses against you. Okay? It's when you transfer it to an innocent third party where I may no longer be able to assert those personal defenses. A few, the real defenses, yes, but the others, no. So keep in mind, if we don't have a negotiable instrument, or if we don't have proper holder in due course status, or protection under the shelter rule, the party who's a third party receiving this debt obligation can certainly try to enforce it. It's just that he or she are subjected to further defenses that holders in course do not have to worry about. Okay? The idea is, to a certain degree, we really want to protect holders in due course and give them special rights with regard to collecting debt where they are innocent of any shenanigans or any problems that surrounded the making of that underlying debt. Okay, the contract, the note's made for the contract, the check's drawn because of the contract. That's between the two parties, not a holder in due course, but anyone else who's not a holder in due course can be a holder, is an assignee by contract. He or she steps in the shoes of the original payee, and any defenses that can be used against the payee can be used against subsequent holders who are not holders in due course. I hope that helps to clarify the big picture a little bit, keeping in mind holders in due course get better status, and to a significant degree, they are free of some defenses that might be assertable otherwise, certainly between the original two parties, but sometimes there's some reason in the law where we can't even protect holders in due course. And so the protection is significant for holders in due course or people who are protected by the shelter rule, but it is not absolute. Hopefully I'll make it a little bit more clear during class, and review of the cases should help that. One other quick thing I recall, there's one new law in there. It's small, but I think it's worth noting. If you see it, with 3302A sub 1 talks about facial non-problematic systems. And that includes not knowing of a fraud, a forgery, or an alteration. What if you see a signature and you don't think it's a fraud? Maybe it is, okay? Well, there's a presumption in 3308 that says if there's a signature that looks pretty good, it is presumed to be valid. If the party whose signature it is alleged to be denies that, he or she has to deny it up front right away. If he or she says nothing, if he or she doesn't produce some evidence with regard to not persuasion, but what is the burden of backing up evidentially? There's a burden to bring evidence to prove that the signature was a fraud. If it was a fraud, no holder in due course status, but the presumption is that it is valid. And so you see in one case, one of the parties failed to bring that up as a defense quickly and lost the right to that defense, which may have been valid had it been properly asserted at the right time. Okay? That presumption of validity, unless properly and timely challenged to be otherwise. I hope that helps, and I'll see you in class.